In July 2024, the U.S. Supreme Court agreed to hear a case about the e-cigarette crisis among U.S. adolescents, particularly the use of flavored e-cigarette products and the FDA's role in addressing it. A ruling against the FDA could have implications for the agency's authority and for public health. I'm Stephen Morrissey, managing editor of the New England Journal of Medicine, and I'm talking with Daniel Aaron, an associate professor of law at the University of Utah S.J. Quinney College of Law. Dr. Aaron has co-authored a perspective article about the case FDA versus Wages and White Lion Investments. Dr. Aaron, how does the FDA typically regulate tobacco products and e-cigarettes, and how much authority does it have in this area?
FDA got its authority over tobacco products from the Family Smoking Prevention and Tobacco Control Act in 2009, although that statute did not apply to e-cigarettes until 2016. FDA oversees e-cigarette products and other tobacco products under a standard called the Appropriate for the Protection of the Public Health standard. In other words, FDA can authorize a tobacco product if it would be appropriate for the protection of the public health. And this is a pretty significant authority that is meant to gate tobacco products to ensure that public health issues do not arise.
You say in your perspective article that in 2021, the FDA announced the denial of 55,000 applications for authorization of flavored e-cigarette products. And that's the decision that precipitated this court case. How did the FDA make that decision?
So, FDA considers an array of factors about a tobacco product. And when it's considering a flavored e cigarette product, it is particularly careful because of the known risks of flavored products to youth. Flavored e cigarette products have a known appeal to youth and have contributed to the youth e cigarette epidemic. So, FDA considers factors like the chemical composition of a product, the chemical composition of the e liquid, the social science factors, the expected appeal to various populations, and ultimately whether the product would foster increased use among youth and whether it would promote the switching of adults from more harmful tobacco products to less harmful tobacco products. And in this case, when it denied the 55,000 e-cigarette related products, the FDA was particularly concerned about the youth impact of flavored products and the lack of evidentiary support for the claim that flavors might help adults more than non-flavored products to account for the increased risk for youth.
And then what happened when those FDA denials were challenged?
Generally speaking, in most lower courts, the FDA won. However, that was not the case in the Fifth Circuit, which has somewhat of an anti-agency track record. The Fifth Circuit concluded two things essentially. That one, FDA had flip-flopped by requiring much more evidence than it said it would require initially before the applications were submitted. And two, that FDA improperly did not consider the applicant's marketing plans. A marketing plan is essentially a plan for how to market a product responsibly so that youth will not be exposed to marketing and to improve the safety of a product, essentially, to promote more adult use rather than youth use. So the Fifth Circuit faulted FDA's decision on both of those scores and invalidated the denials, which was a pretty striking result. Although there definitely was some contention at the Fifth Circuit because different panels of judges made different decisions. And in the end, the entire court with all of its judges had to sit together, what's called en banc, in order to actually invalidate the FDA's decisions.
What would be the implications of the Supreme Court's agreeing with the Fifth Circuit's decision in this case?
The Fifth Circuit's decision is quite harsh toward the FDA in several ways. But first, zooming out, there is a larger battle over the authority of the United States public health and medical agencies. And essentially, the courts have proved a pretty inhospitable place for public health regulation. And moreover, there currently seems to be a shift toward a more intense scrutiny of agency decisions that involve science. Last term, we saw a very important case about mifepristone and FDA's scientific decisions related to that abortion-related medication. And the Supreme Court docked on that case, largely because it seems it was an election year and perhaps the Supreme Court did not want to wade into that. However, now that we're not in an election year and we're not dealing with something as contentious as abortion, it's possible that the Supreme Court will use this opportunity to undermine the authority of the FDA. And it's important to see the parallel with drug regulation. FDA also has a gating function with drugs. it decides whether new drugs should enter the market, and barring that, the drugs may not be marketed. And so, if FDA's authority over tobacco products, if its ability to review them before marketing is questioned, that could spell an increasing judicial intrusion into FDA's drug-related decisions. On top of that, FDA, when it reviews products, does sometimes give informal guidance to industry, and that has proven pretty important for both drug and tobacco regulation. This case is an attempt to use perceived inconsistencies in FDA's informal communications to invalidate very large regulatory actions, very large regulatory decisions. And so, what that could mean is that FDA might be discouraged from providing industry guidance in order to meet regulatory expectations. FDA does have the authority to simply approve or review applications on a case-by-case basis without providing upfront guidance, but that certainly wouldn't be that great for industry. And ultimately, it's not clear that a decision against the FDA here will encourage it to provide better guidance. It may actually cause the agency to provide less guidance while allowing a number of e-cigarette products that the agency determined were inappropriate for the protection of the public health onto the US marketplace and the potential downstream negative impacts on the public health.
So the case was argued before the Supreme Court in December. Was there any indication of the direction that the court might take?
Law professors tend to avoid being too confident with their predictions on Supreme Court decisions, but it definitely seems like there were a number of justices pointing in both directions. There were several justices, such as Justice Gorsuch and Alito, that expressed some skepticism to the agency, whereas Justices Kavanaugh, Jackson, and Kagan seemed to be in the camp of supporting the FDA. So it might actually be quite a close decision, but certainly the stakes are high and physicians should be aware of these cases. In parallel, physicians should be aware of the parallel tobacco case in which the Fifth Circuit allowed litigants across the country to bring their cases in the Fifth Circuit, thus avoiding all the other circuits that had ruled in favor of the FDA. And that seems to be quite an aberration and a way to kind of circumvent less friendly judges and to find a friendly forum in the Fifth Circuit. So one might hope that the Supreme Court might be skeptical of that procedural tactic.
Finally, as you say, this case has to be seen in the context of courts potentially controlling and overriding expert agencies. What do you think this shift will mean for agency decision making in the years to come?
The first thing I want to say is that it's very possible the Supreme Court will side with the FDA here. Nevertheless, it seems like a number of science-laden agency decisions are landing before the Supreme Court. And so it may be a matter of time before the Supreme Court increasingly tries to get tangled with these scientific decisions. And in fact, last term it did in Ohio versus EPA. The Supreme Court ruled against the Environmental Protection Agency and invalidated a air pollution rule. And the reasoning for that was that the agency, the Environmental Protection Agency, had not adequately explained its decision by failing to respond to a single sentence of an industry comment. And so there's a way that even though the Supreme Court might say that it's not tangling with the science, it actually is reading agency decisions with a fine-tooth comb and looking for little flaws that can be used to undermine agency authority. And so we should be on guard for kind of the subtle intrusion of courts into scientific decisions. And so as we see more and more Supreme Court terms in which these science-laden agency decisions come before the court, we have to be aware that it's possible the Supreme Court will kind of embrace the shift that we saw in Ohio versus EPA and start being more skeptical, even in cases where it doesn't have expertise. Judges are not trained in scientific medical programs. They are trained in law school. And so they don't have the chops really to handle these kinds of decisions. And yet, these science-laden decisions can be quite vexing for judges if they have ideological proclivities that oppose this kind of scientific decision, for example, with the abortion pills. So I think the jury is still out on what will happen over the next few years.
Thank you, Dr. Aaron.